Hi, everybody. Hello. Happy New Year to you all. Hi. Did you have a nice break? No, some of you are like, no, I've been working. Oh, sorry about that. Well, I hope that you managed to have a little bit of time for relaxation. Did any of you see any fireworks on New Year's Eve? Stay up for New Year's Eve?
I didn't have to leave my kitchen to see the fireworks here in Townsville.
Oh wow, that's pretty good.
Yeah.
We had fireworks in Cairns, but it rained really heavily rained. So we actually drove to the top of a hill and sat in the car and watched them. Just very lazy. Normally go down the beach. Okay, so welcome to week 7. So this week we are looking at communication, focusing on communication, thinking about how we present things in terms of presenting information to an audience, specifically the marker for the problem solving assignment, but also starting to look beyond that as well. We're going beyond this immediate assessment task, and we're looking at how to break down a question, how to interpret and apply a question that is not a problem question. So looking at theoretical essay questions as well. And also very briefly talking about the role of lawyers and how they communicate with their clients, with third parties, with their opponents, etc. So quite a few different concepts of communication or communication in different contexts this week. I've got a little thing at the end. It'd be great if you can stay around for the end, even if we run over, because I'm going to put up 2 extracts of students' work. It's not the problem solving assignment that you've been set, but just to show you the difference between 2 extracts and getting you to start thinking about what communicates information effectively, and what a decent paragraph should look like. Okay, so let's start with the questions that we've been set. So the first one is critically evaluate the claim that advocacy in contemporary legal practice means fighting for your client's rights. So how would you, if you were faced with this question in your final assignment in week 12, how would you approach it?
I would have a look at what rights the clients have first.
Yep.
The foundation for any arguments that I may need to make.
Okay, good. So what do we mean when we say client's rights? Because of course, if you don't know what that means, then you might be arguing counterintuitively to the position. Okay, good. What else?
And are they human rights or are they rights of consumer rights? Those, we need to differentiate.
Yep.
Narrow down what it is, I suppose.
Yeah, so seeking to enforce their legal rights, such as being able to claim in a breach of contract or being able to sue a negligent doctor, if that's what you mean. So sort of legal rights rather than their basic human rights. Okay, good. Yeah. What else might we need to look at before we actually start working on this? What does critically evaluate mean?
Use the logic.
Yep, absolutely. So it's got to be methodical, and you'd certainly want to plan this before you start to write it, okay? Because your structure and whether you've adopted a logical approach to the question is part of your grade. It's also part of effectively communicating your knowledge and understanding to the marker. But other than logic, what else does critically evaluate mean?
Isn't it also balancing, knowing the client's information as much as possible? So asking as much as question and then use the advocacy to actually win in the courtroom.
Yep. Okay. So you're right, but in relation to a theory question, so this is a theoretical question, isn't it? It wants you to evaluate the statement. So I guess what critical analysis means in that context. So you don't have a set of facts. You don't have a problem scenario. You don't have a client to advise. Here, we've got to look at a statement and then analyze that statement. Okay, so that's a theoretical essay question. In those instances, when we see the words critically evaluate, it means that we need to assess the statement. Now, that sometimes means breaking down the statement and identifying what is meant by particular words or phrases. So we've already had that. We've already said, what does a client's rights mean? Yeah, so that sometimes means breaking down the statement. Once you've managed to do that, critical evaluation involves playing devil's advocate. In other words, looking at the arguments from both sides. It's not a one-sided, it's not a one-sided argument. It's one that looks at the strengths and weaknesses of both sides. Okay, so it's about evaluating both sides of the argument thoroughly. That doesn't mean you can't conclude on a particular side, right? That you can say, oh, this is the best position to adopt because. But to get to that point, you've gone through a reasoned logical process where you've looked at the strengths and weaknesses of both sides before you've adopted a view. So it's a very considered approach. Okay, so what we're talking about is balance, really. It needs to be free from bias. So your own view needs to be formulated on the evidence that you present in the document. Okay, so the discussions that you have, those strengths and weaknesses, but also the evidence that you present as well. So without bias until you reach your overall conclusion. It must, to engage in critical evaluation, you must identify suitable sources as well. So that's not Wikipedia, it's not a random Google search, and it's certainly not Facebook, okay? It's about suitable sources. Now in law, if you're writing about the law, you should be citing primary sources. So primary sources are statutes or cases. But if you're not telling us what the law is, but you're discussing the law and talking about the law's strengths and weaknesses. Let's say, for example, that you want to argue that the domestic violence reforms have not gone far enough. And so they don't provide adequate protection for women and children who are subjected to domestic violence, for example. Let's just say that that's your argument. Then you want to, in those instances, you would still tell us what the law is to identify that it's not gone far enough, but you can then start to talk about secondary sources to support what you're saying. And those secondary sources might be comments in journal articles, okay? And they don't necessarily have to be law sources either. It could be psychologists or criminologists or social workers who have written journal articles on the topic. You can use material from other disciplines as part of your analysis, but they still come from peer-reviewed journals. In other words, they've been through a rigorous process to test the credibility of what's been written. It's not some random blog on a web page. Does that make sense? Okay, so chapters in edited books have also gone through peer review process. Other materials, you can look to things like newspaper reports if you want to talk about what the media has been saying about an issue. But remember that the media isn't always the best fact checker. So you're not necessarily getting what you need from a newspaper report. So just exercise some caution there in relation to that. Okay, so we have to use suitable sources when we make arguments. So you could argue that, when you're evaluating the statement, that this particular aspect of it is a weak argument, and here's a source to support what I'm saying. And then, of course, the final step in the critical evaluation is, of course, to make sure that you do reach an overall conclusion at the end. And that conclusion has to really reflect the discussions that you've had throughout. Okay, so what we're trying to do here is understand what we mean when we use the word critically evaluate, sorry, because we need to really know what the question wants us to do with the rest of the statement. So it starts with critically evaluate, but then we've got the rest of the statement and we need to work out what it wants us to do. So critically evaluate the claim. So there's a claim by someone that advocacy in contemporary legal practice means fighting for your client's rights. So when we are critically evaluating that contemporary practice means fighting for your client's rights, we need to present a balanced view about that with sources in support. Okay. Now, before we get to that stage though, as I said earlier, we've got to break it down and work out if there are any aspects of the question that need to be explored before we can fully engage in that analysis. So one of the things I would ask is, well, what's meant by advocacy? Okay. And another thing would be, what does fighting for mean? I mean, we all know what the phrase fighting for something means, you know, colloquially when we're with our friends and we're talking about whether that lawyer fought for their client. But what does it really mean here? Is it the broad meaning of outside the courtroom? It includes, you know, negotiation, for example, or is it the narrower interpretation of it's talking about what you do in the courtroom as an advocate? So I think advocacy, fighting for, and clients' rights all need to be explored before you can engage, you know, thoroughly in an evaluation as to whether the statement is true or false. Because that's really what we need to do. Okay, so let's talk about what is meant by fighting for. First of all, how would you define fighting for?
Would it be standing up in support and finding ways to basically make your client win, like fighting for their side of the argument on their behalf?
Okay, so you're talking about that adversarial, very traditional way of viewing the legal system and legal process, and even legal practice, which is that it's us versus them, and one of us is going to win and one of us is going to lose. And when we fight for you, we're really pushing forward everything that we can to ensure that you win. Yep. So it's fine if you take that definition, you'd make that clear, obviously, in your work so that the marker and the reader understands your definition and how that frames what you're going to write. Okay. But I guess we can evaluate that in itself. You know, is that true? Is fighting for always adversarial? What do we think?
I think it can be more diplomatic than that. There is the advocacy part of it and fighting for someone's rights. You could be going to look for middle ground that makes everyone happy. And of course, it depends on what rights were breached and how they were breached as well, in what the context is around fighting for someone's rights. You could go in as an adversarial fight for someone and their rights, but you could also be going in to negotiate someone's rights, whether it's with the government or a company, to get a better outcome for your client, but also something that is not, I guess, looking blood.
Yep.
One of a better word.
Okay, very good. So I think, Shay, what you're actually recognizing there is that not everything is an absolute battle to the death, which is kind of what the question implies, that it's this kind of courtroom win-lose battle. You talk about negotiation there, and of course it's the case that most lawyer work probably occurs outside of the courtroom anyway. But think of the situation like this. You've got a commercial tenant and a commercial landlord, and the commercial tenant wants to rent premises from the landlord. They both want the same thing, which is that they both want a lease that is on reasonable terms for them, okay? But they both want to achieve an agreement. In that situation, they're not really at loggerheads, except for the fact that they might disagree on the odd term here and there. And, maybe it's about how many weeks' notice have to be provided or when rent can be increased or whatever it happens to be. But in that situation, contemporary practice is about just working together, the two sides working together to find a reasonable solution, a reasonable lease agreement for both parties. In that situation, the negotiation isn't adversarial. It's not about saying, this is what I want, your client's going to give me what I want. It's about saying, sometimes there's a bit of give and take, and it's, okay, well, we'll change that clause, but we need you to change this clause. It's really much more of a jigsaw puzzle to reach an overall agreeable solution. So that's one point, which is that, outside of the courtroom, much of the work that lawyers do is not about loggerheads and battles and a winner and a loser. It's about finding something that's mutually acceptable. The other thing is that when we talk about the courtroom specifically, I don't know which of you were here when we did the week one, but we looked at the clip from A Few Good Men, and do you remember Tom Cruise was shouting at the witness? The witness was Jack Nicholson. Because Tom Cruise was quite passionate about his client being wrongly accused of manslaughter, but also because he was very annoyed that the colonel was exploiting his position of power to hide behind what he had done, which was to make a code red order. So there was frustration in there. There was also the fact that Jack Nicholson was being belligerent. And so Tom Cruise attacked him quite aggressively in his cross-examination. And in that session, if you remember, we talked about whether or not that was likely to happen in Australia. And we said it was very unlikely. It's much more polite and courteous in the way that we deal with witnesses, even when they're being really difficult. It's still very courteous. And why is that?
Because you're more likely to get someone to cooperate with you if you're kind and polite than rude and aggressive.
Yeah, absolutely. It's also the fact that I think what you're going to end up with is the judge policing your behavior rather than focusing on what you're trying to establish, which may be that the witness isn't credible, or they have a really poor recollection of what happened, or whatever it happens to be. There's also tactically, that's not a good idea, because you might create sympathy for the witness as well. If there is a jury, if the jury feels that the witness has been unfairly treated in the cross-examination as well. But, there's across the legal profession generally, you are expected to avoid being sarcastic, aggressive, or demeaning in the way that you deal with other people, whether it's witnesses, your opponent, the judge, or third parties. And that's because it can be quite distracting, as I've already said, but also because it's a professional conduct issue too. So in the Australian Solicitors Conduct Rules, Rule 34 looks at the way that you deal with other people. And it says that lawyers must not use tactics that go beyond legitimate advocacy, and which are primarily designed to embarrass or frustrate another person. And peppered throughout the Australian Solicitors Conduct Rules are things like that, about the way that you conduct yourself with other people. So there's an element of you have to be very careful of the means that you adopt when you're trying to secure a particular outcome. And I think that's partly because it can have a significant impact on the justice system and its participants. It can make the trial unduly stressful for the witnesses or the parties. And it can also engender questions in the community more generally about the reliability of the result. You know, we are all able to go and sit in court and watch justice occur. And so what would your perception of justice be if you can see the lawyers, you know, attacking someone and insulting them or being sarcastic? You would question whether the system is able to be impartial and deliver an unbiased result. And of course, that's what the court is there to do, which is to provide an unbiased outcome for two parties that are in dispute. Okay, so there's lots of reasons why the narrow interpretation of fighting for your client, which implies doing whatever it takes to secure the outcome that you want, there's many reasons why that interpretation is a dangerous one to adopt, because as I've already said, you know, it doesn't reflect the reality of negotiation and practice outside of the courtroom. And even within the courtroom, those kinds of behaviors should be avoided for a variety of reasons. Now, that doesn't mean that you don't act in your client's best interests, of course. What do you think is meant by the client's best interests? Like, okay, could you lie to the court, for example, or hide something from the court because if it's revealed, it's not in your client's best interest?
Isn't to
That would be
reach the
unethical.
possible. Oops.
Whoever said it would be unethical, yes, you're absolutely right. So there are limitations. Whilst your client's best interest is one of your primary duties, that is always subject to your overriding obligation to the administration of justice. Okay, so in that situation, you couldn't deliberately hide things from the court. You couldn't lie to the court and say that your client was not guilty when they told you that they were guilty. There's all those kinds of things. And that's because the administration of justice must prevail over everything else. So that's also part of that community perception as well. And integrity and ethics, therefore, kick in. But having said that, you know, outside of that context of lying on behalf of your clients, you can structure your submissions and the way that you run the trial from the perspective that works best for your client. And that's what lawyers do. You know, they obviously advocate and put forward an argument that suits their client's position. And then the other side do the same. And then the court works out what is actually the appropriate position to adopt. Now, when we talk about clients' rights, so going back to what Shay was saying earlier, again, you need to explain what interpretation you've adopted there. So if you take Shay's approach of, well, clients' rights could be human rights, but that's quite different to legal rights. Yeah, legal rights are that you've got a claim or you're defending against a claim, and it's the best position or the best argument for your client in relation to that claim or that defense. So what about human rights though? So for example, the right to a fair trial. What do we think about that?
I think that's talking about the fact that even if the person has done the wrong thing, you're still fighting for their rights in regards to getting the best possible outcome. So they've broken the law, but you don't want them to be treated unfairly, getting longer jail term or more penalties than what they should have got, if that makes sense. So.
Absolutely, yeah. So in those instances, it's about, again, ensuring that justice occurs. So being part of that system of the administration of justice. So acting for someone, even if they are guilty, enables them to have a fair trial, which means that they're treated equally, because rule of law says that we're all equal before the law. So in that instance, we are in effect ensuring that justice occurs. Absolutely. Interesting though, if we look at criminal trials just for a second, we'd all agree that the job of the defense lawyer is to represent or put forward the defendant's defense in the best manner possible for that client, right? It's to present the defense and challenge the prosecution's case as well, but to present the defense and challenge the prosecution's case in the best way for that client in those circumstances. But what about the prosecutor? What's their role in a trial? Because they don't have
ensure that, like,
Sorry.
to ensure you're right, to ensure that like justice is served, so that, you know, even though they've done the wrong thing, they've broken the law, you know, okay, they might have had a valid reason for it, but you still can't break that law. It's there for a reason.
Okay. So who's the prosecution acting for, though? Do they have a client?
Yes, they do. Isn't it the state?
Okay, yes. So it's the state, but they're not acting for the victim is really what I was getting to. So much as obviously the victim is relevant because that's why the offence has been charged and prosecuted, right? They're not actually acting for the victim. And so they're not positioning their case in the best way that suits the victim. Okay, they position their case in the best way that is suitable for the administration of justice. So the prosecutors see their role as part of the process of ensuring that justice in the criminal setting occurs. Does that mean that they can, in all of this context, could they hide evidence that might help the defense, do you think?
No, because it's still unethical.
Yeah, so it's about, again, they've still got a responsibility to ensure that there is a fair trial, and that means disclosing evidence to the defense that is adverse to the prosecution's case. And if you know of the Lawyer X case, Nicola Gobbo, the gangland lawyer, so the prosecution in Victoria became aware of the fact that she had acted both as a lawyer and given information to the police on those in relation to those clients. So she's obviously breached her ethical duties there, or at least it's alleged that she has. And so the prosecution became aware of that and had to disclose it to people who had been convicted of a range of crimes and were in jail. And those convictions have now been overturned. So you see there, that's completely adverse to the prosecution. They managed to secure a successful conviction that got the relevant individual sent to jail. Then they subsequently became aware of this situation where there's a big question mark over the evidence that's been gathered because of this dual role that's been played. And so they had to disclose that to those people who had been imprisoned, found guilty and imprisoned, on the basis of that evidence. So we can see here that really the prosecution's role is quite different in that setting to the defense. So again, whether we can say that they're fighting for their clients, that might apply to the defense, but again, wouldn't necessarily apply to the prosecution. Okay. And then we've got, and of course, they're not, if the prosecution doesn't have a client, they can't be fighting for clients' rights, whatever that means. And as I said, the defense are still limited by ethical considerations as well. And then I guess we also need to talk about what we mean by the word advocacy. What do you think that means?
To speak on behalf of you and represent your client, or be present on behalf of your client in this context, I guess, before the court.
Yep. Okay. So again, you need to make it clear how you've interpreted that. If you're going for the narrow interpretation of the courtroom, so representing a client in court, make that clear. The word advocate, though, is actually broader than just courtroom action. Okay, so you can advocate arguments on behalf of your client. You can advocate a particular position in a negotiation. You say, this is why you need to give me this settlement, because here my client is right on these, and these points. So you need to give me a settlement that reflects the strength of my client's case. So Absolutely, Tammy. So you could take a broader approach of convince as your audience. In other words, put forward arguments, advocate, put forward arguments on behalf of another. Okay. So again, make sure that you are clear on how you've interpreted that. Bear in mind that a large proportion of what solicitors do is advocacy in the more broad sense of negotiation on behalf of clients, and that only a small percentage of cases reach litigation. A lot of cases are non-contentious anyway, so they're things like wills, drafting contracts where both parties want a contract, drafting leases and sales of property where both parties want the same thing. So that's non-contentious. But even in contentious litigation, only a small slither actually end up in court. Most of them are settled or are resolved some other way. Okay. So we'll talk a little bit more about that over the coming weeks. We'll talk about the non-adversarial role of lawyers in terms of negotiation and access to justice and all of those kinds of things. Let's talk now about, just before we do that, I just very briefly, this is just slightly off topic, but there's a great perception amongst law students, particularly in the early days, that you're not a good advocate unless you win. As in only good advocates win cases and poor advocates lose cases. So someone with a really good win record must be an amazing advocate, and someone with a poor record of winning must be a poor advocate. And it's not, the formula doesn't work like that. It's not as straightforward as that. You might have people who take on a lot of pro bono work where the cases are relatively weak, but they want people to have their day in court, and or they're testing new novel points of law. You can have situations where it's nothing to do with the advocate and the witnesses just came up to proof on the day and were pretty convincing when they delivered their information to the jury or the judge, or a situation where the case looks good on paper and then the witness falls apart on the stand, and it's nothing to do with the advocate that's running that case. Their witness just doesn't stand up to proof. So there are a whole bunch of reasons why people might lose a case and still be an amazing advocate. And trial advocacy is very different to appeal advocacy as well. So being a trial advocate, there's a lot more thinking on your feet, and a lot more sort of cross-referring different bits of evidence and putting that to and questioning the witness on that. Whereas appeal advocacy can be quite theoretical and engage in discussion with the judges about the law. So, different skill sets involved in those two things as well. So just bear in mind that it's not a simple formulation like that. And you can be a nervous advocate and still be really good. So I don't want you guys to think that you'll never be a good advocate just because you feel nervous when you engage in public speaking. It's something that even good advocates still get nervous. In fact, my supervisor said to me when I was training, the day that you stop being nervous is the day you should retire, because you should always go in there with a bit of adrenaline, because it ends up being a better performance in the long run. I used to get sort of a shot of adrenaline when I stood up to introduce myself, and it'd last for about 2 minutes, and I'd be pretty nervous for the first 2 minutes, and then I'd just settle down into it, and it, from that point onwards, it would go fine. So I don't want you to think that if you get nervous in public speaking, that means you'll never be good at advocacy either. Okay, you will, I promise. It just takes time. Okay, so question 2. Identify 5 traditional legal writing practices that lead to unnecessarily verbose and complicated legal documents. Explain why each is unnecessary and describe how each can be avoided in order to produce a document that is written in plain English. Now, if any of you do legal drafting as an elective, we look at this in a lot of detail. That's one of my elective units. But let's talk about examples of poor writing. So what's one of the things off the top of your head that may indicate verbose or difficult writing to read?
The long and complex sentences.
Yeah, Absolutely. And that's really common in legal documents as well. It stems from the fact that lawyers were paid by the word once upon a time, and so they like to develop lengthy documents because they got paid more. And of course, those phrases and words then became the precedent for how you express that particular thing, like give, devise, and bequeath, which basically just means I give. Okay, so in those situations, you know, they just became the norm that everybody used, and everyone just trots them out or copy. In these days, we copy and paste them over. But what we need to do is think very carefully about sentences. The most effective communication takes place in a short number of words, because then there's less possibility of ambiguity. Okay, so the shorter the sentence, the less ambiguity. You need to, so if you've got 3 things that you want to say, have 3 sentences, okay? Rather than and or lots of commas joining them all together. So 1 point per sentence, and preferably 1 idea or topic per paragraph. Okay, so if you were looking at a breach of contract scenario, you wouldn't want to have whether there's a valid contract and whether the contract was breached in the same paragraph. Okay, they're 2 separate topics, 2 separate ideas. So they should be under either separate headings or separate paragraphs. Then within each paragraph, you want 1 point per sentence. Using headings also really helps flag to the reader what will follow. Okay, but that means you've got to be very good at writing your headings so that they really reflect what's about to come. What else is wrong with the way that lawyers express themselves sometimes?
Being unclear and not concise.
Yep, absolutely. So being verbose, so long-winded, and long sentences is, we've already had that one, but being verbose, again, that's what we're talking about there, is lawyers not using plain English to express themselves, but long words, really long words, complicated words, words that you need a dictionary for. Okay, again, that makes the information difficult for the reader to digest, and might be okay when you're writing to an opponent, but if you wrote that to a client, they're probably going to call you and say, I didn't understand the letter you sent me. So then they're going to get annoyed because they've got to pay your bill, or should I say they'll probably refuse to pay your bill for the letter that they can't understand. Okay, so you really don't want to be communicating with your client like that. The same is true of third parties, and by that I mean expert witnesses, the local counsel that you need some information from. Again, they don't want to be finding a dictionary and having to look up what you've said. They just want to know, what do you want to know, and what's the most efficient way of me giving you what you want to know. So what we need to do is make sure that we avoid the temptation to write in verbose language. Often students think that it makes them sound more like a lawyer and makes them sound more, intelligent. But ever since the plain English drafting movement took hold, lawyers strive for the opposite. They look for plain English drafting, using words that everybody can understand. So writing for all audiences. So again, stick to 1 point per sentence, keep sentences short, use language that a client would understand, don't use jargon, and certainly don't use legal terms. If you have to use legal terms, explain what they are. So if you would say, we must file a counterclaim, that's a legal term, counterclaim, your client won't know what that is, so you need to actually explain what a counterclaim is. Okay, so it's a claim against the plaintiff who has already commenced an action. Okay, another example of poor drafting.
The double negation, where I think I was reading something about that when you say yes, it's actually right, but it sounds like you're admitting to something you've done wrong, if that makes sense. Sorry.
So, I mean, that quite often occurs in cross-examination and can be quite tricky for people who are not used to a number of negatives in a sentence. So you weren't there on that day, were you? So you've got a positive and a negative there. You weren't there on that day, were you? So with a positive and negative, you end up with a negative. So then they have to work out, okay, so if I say no, that's a positive. Okay, so try and avoid having two different, like a positive and a negative, or two positives or two negatives together in a sentence. So just say you weren't there that day, question mark. Okay. Or I put it to you that you weren't there that day. Okay, what else do lawyers use that's not helpful?
Have we mentioned misuse of grammar?
Okay, yeah, and what do you mean by that?
I don't know. It'll be like, semicolons, commas, exclamation marks in different or in incorrect passages or paragraphs or sentences.
One of my pet hates is semicolons. If you don't know how to use them, don't ever use them. They can really destroy the sentence. There's a number of cases in which, litigation has been won or lost on the position of a comma. So, the comma has affected the interpretation of the contract, which has consequently affected the rights of the parties, and therefore resulted in one party obviously winning and the other party losing. So again, really careful attention to grammar. And that goes back to that shorter sentences. If you can keep it short and avoid commas wherever possible, then you're going to reduce the risk of the relevant sentence being interpreted in a manner that's adverse to your client. What we've got, using Latin. Yeah, so I already mentioned that, we avoid using Latin wherever possible. Having said that, there are certain phrases in law that don't have a plain English equivalent, like the word estoppel. So if and when you do contract law, estoppel means stopping someone from going back on their promise that they made, their representation that they made to another, where the person that received the promise relied on that promise. Okay, so that's really, there's no short word that is the equivalent of the word estoppel. It's a concept. So in those situations, you really need to explain to your client what that is if you're going to have to mention it in your letter to them, for example. One thing that I was thinking about was passive voice. What's the problem with the passive voice?
It's infuriating for a start. So I think the passive tones or false accusatory statements, if you will, like a negative tone, that's the thing that gets me. I've had some relations just in civil matters with business before, and I've had other companies who have written legal, had their legal representatives write me letters, and they've been basically stating that I've done this and that I haven't got a leg to stand on and I'm gone. And then I get my back up personally. I think, well, that's wrong. I disagree. And on those occasions, I have taken them to court and won, which must be extremely embarrassing for them after the way they've carried on. But I think it's better to keep it neutral and just talk about the facts, if you will, on a really sort of bipartisan or impartial point of view, instead of taking that passive tone.
Yeah. Okay. So you're talking about tone in the way that you communicate. Absolutely. So that goes back to ethical issues as well, in the way that there's a difference between strongly putting your client's case and aggressively putting your client's case. You need to be careful in that regard.
It's not picking a fight for the case itself.
Yeah, absolutely. But the passive voice is a concept based on the structure of the sentence. So the passive voice puts the person doing the action at the end of the sentence. And I'll give you an example. So the example is, David was struck on his left cheek by Rodney. Okay, so we know that Rodney has, punched David and hit his left cheek. But the reason why that's in the passive voice is because the person doing the action, who's the person doing the action in the sentence? Who's doing the verb? It's Rodney. Rodney is striking. Okay. So Rodney comes right at the end of the sentence. We have no idea who does the action until the very last word. Okay. So David was struck on the left cheek by Rodney. Okay, so Rodney is the person doing the action and they come right at the end of the sentence. That's in the passive voice because the usual order for a sentence should be subject, the person doing the action, the verb, and then the object, which is the person receiving the action. Okay, so it should be subject, verb, object. So it should go Rodney strikes David. Does that make sense?
It does, yeah. Why is that, just out of curiosity, why is that a problem? I get the grammar, but why is that a problem?
Because it makes, in longer sentences where there's more detail, it makes the sentence quite complicated. So it adds extra words. We don't know who's doing the action. We don't know the main instigator in the sentence until the very end. And it's also less engaging for the person listening or reading the information. So passive voice is something that lawyers use all the time, but is heavily criticized. So in that instance, the sentence just needs to be rearranged so that Rodney struck David on his left cheek. Yeah, rather than David was struck on the left cheek by Rodney. Okay, so subject, verb, object is the usual order. Finally, other things that we need to think about is adopting sort of gender neutral language, non-discriminatory language. None of those necessarily are present in legal writing. You know, lawyers don't necessarily tend to write like that, but we do need to be mindful of that in our own writing. So, for example, one of the things that we quite often see in law students' work is that they tend to refer to everybody as he. And it's now convention in terms of drafting of statutes, for example, to draft in a gender neutral language, and we need to mirror that ourselves. Okay, we need to follow what Parliament is doing in that regard. In the old days, it used to be that a person can commit a crime if he does the following, and that's how they used to draft statutes in the old days. So things like that. Okay, any other examples of poor writing that you guys can think of?
Yep, failing to link the law to the points that are raised and being lacking in authority.
Yeah, absolutely, good one. So we always use authorities to support our assertions, but not just any old authority grabbed from Wikipedia. It's suitable authority, which if you're telling me what the law is, it should be a primary source, it should be a statute or a case. Okay. If you're analyzing the law, then secondary sources are great and fine. But again, think about the credibility of the source. Think about whether it comes from a peer-reviewed journal or a highly credible source like the Australian Bureau of Statistics, or whether it's something that you've grabbed from a questionable source. Okay, now what I would like to do now is show you some extracts of, here we go, this is what I want to show you, I'll just make this bigger, just give me a sec. Sorry. There we go. Some extracts of some students' work, okay? So these here, there's two. One will receive a higher grade than the other. So what I'm going to do is I'll let you read extract 1 and then you can read I'll scroll down and you can read extract 2. I want you to think about which one you prefer, but more importantly, why you prefer that extract, okay? Which one communicates more effectively, adopts the IRAC approach more clearly, and therefore produces an overall better product. Okay, so that's extract 1, so I'll just give you a minute or two to read that. You can all see that, can't you? Yeah, okay. Okay, anyone need any more time on that one? No? All good? Right, so that's extract 1. This is extract 2. So I think I know what the answer is already, because you guys, I can tell from your faces. But let's just stop sharing that and run a quick poll. Okay, so let's have a look. All right, so I'm launching the poll. So which extract will receive the higher grade? Is it, this is anonymous by the way, is it extract 1, the first one, or extract 2? Okay, and everybody's voted. And I'll share the results, but it's no surprise because 100% of you agree extract 1 is better. And it's definitely the case that extract 1 would be graded higher. They actually both say their point is the same, okay? Both say the exact same thing. So we give them both a tick for understanding the doctrine of precedent, right? But the problem is that the way that it is communicated is very different. So the first one communicates it much more effectively and therefore will convince the marker quite easily that the student understands the law and can apply it to the scenario. Okay, whereas with the second one, you're kind of left in a little bit of doubt as to whether they really understand what they're talking about when they can't communicate what they know, right? So that's why the spelling mistake made me dismiss the second paragraph. Well, that's a little bit harsh because, you know, I'm pretty sure that most people have at least one typo in their work. But what frequent typos tell me is that you've not proofread your work. Okay, one typo that you've missed is quite different to multiple ones. If there's multiple typos, it tells me either you've not spell checked or you've not proofread. And both of those things are part of the finalization of the document. And so it tells me you've rushed it. You're up against the deadline and you've rushed it. Now, whilst that, you know, you might think, oh, well, you know, that's just the way it is being a student. You can't adopt that approach in practice, okay? You can't put something into court and then go, whoops, sorry about the 15 typos that's in the document there, Your Honour. So we need to get used to editing and proofing our work. Okay, so let's go. I'm going to reshare the screen and we're going to look at the second extract and talk about why you guys think that it's poor. Like if you were grading it, where did I go? If you were grading it, what would you say is wrong with it? What feedback would you give?
To me, it sort of keeps going around in a circle, like they're rambling on. It's like, get to the point.
Okay, good.
Yeah,
so
it's lengthy.
Sorry, go
It's
on.
lengthy and yeah, it's lengthy and it's not concise. It's not straightforward and it's not to the point.
Yeah, absolutely. So this sentence here, which is nearly 6 lines long, is firstly it should be broken up, right? Because there's more than one point there. It's 6 lines long. If you've got to make a reader read 6 lines before they understand what you're saying, then there's something wrong. But also we see from the previous extract that they managed to say that in probably 2 lines. So what's written here is just as you say, going around in circles. It's almost like they don't understand quite what they don't quite understand the concept. So they've written it in a couple of different ways to try and communicate their understanding of it. So that's a really problematic sentence, that one there. And of course, with them, it's got multiple commas in it where there should be full stops. So like here, we've got lots of whiches, but here, you could start a new sentence here, and you could start a new sentence with although. So, that could be broken up just as it is, better than it presents. But also it repeats itself. It's repetitious in the way that it communicates the information. So that's quite problematic. Here also we've got I think. Now, generally, we don't refer to our own view in problem questions. We adopt the position when we're asked to advise a client. What we're really doing is telling them what the independent court would do when it deals with this dispute. So to mirror that, we adopt an objective way of talking about the case ourselves. So rather than using I and we and even you, we say, oh, the client this, or use the client's name, and we avoid expressing our view at all. We just say it is most likely that the client will lose or win, so frame it objectively. So we've got that again down here as well. We've got in my view. You could put there, it's likely that the magistrate's court will follow its decision. Okay, the other thing is that there's no authority here whatsoever. So there's no reference to cases, statutes, but we're actually talking about the law. We're talking about a rule being that the full High Court's decisions are binding on the magistrate's court. Okay, as we're talking about a particular rule, there should be an authority in support. And we saw that in extract 1. So let's just flick back up. Can you see here? We've got, according to Rowland, decisions of the full High Court are binding on all courts across all states and territories because it is a court of common apex. Okay, so there they've incorporated suitable authority to support their explanation of the rule that they are applying. And here we've therefore got that clear IRAC formulation. We've got here we've got the explanation of the rule. The High Court is a court of common apex, it's binding. And within the explanation of the rule, there's the citation of the authority in support. And then here, we've got the application. Okay, this means that the 2018 decision is binding on the magistrate's court. Does that make sense? So for the marker, this is a really easy grading because you just go, wow, well, we've got the explanation of the rule, we've got the application, it reaches a conclusion, and it's got suitable authority and support, tick, tick, tick. Okay, and it's short and concise, 1 point per sentence, and generally well expressed. And then you come to this one, and it's a bit all over the place, doesn't like the authority, it lacks the authority and support. And the only thing that it really does is apply the law. It doesn't explain it very well. Okay, so the application's there. It tells us that the magistrate will have to follow the decisions. Although here, I mean, that's confusing. When it says is it talking about the magistrate's court or the full High Court? But yeah, at least they attempt to apply the law, but the explanation of the law is just really all over the place and not clear at all. And that's just multiple commas, not sticking to 1 point per sentence, not thinking about that IRAC methodology leads to two very different results. So one's a bare pass and the other's, probably a credit. So possibly even a distinction depending on the rest of the paper, obviously. So, we've got two very different results, both trying to do the same thing. Any questions about that? No? Okay. So it's very much a case that, you can, your communication of the information in your assessment item is actually still really important. Even if the criteria rubric says that, you know, expression is only worth 10% or something. Even if it says that, actually communication can block your demonstration of your understanding of the law, or it can block your demonstration of your ability to apply the law. Okay, so actually communication is more important than it first seems, because it's making representations to the marker about your level of achievement. It's the communication is the means by which you demonstrate your skills and knowledge. Okay, any questions about anything that we've covered tonight? Nope. Okay, now I did put, so in the Q&A surgery area, I've put some questions that I've received from students over the course of the last week or two, and put an answer up there so that everybody's got the same information. So it's like a, you know, frequently asked questions area. So make sure you check that out. I haven't identified which students have asked which questions. Don't worry, your questions are safe with me. But it's just there so that you guys have all got the same information about it. In terms of, but I'll repeat some of it here because I think it's really important. In terms of the split between the reflection and the actual problem, question, answer, your reflection should only be around 200 words. There's flexibility there, but around 200 words. The bulk of your work has to be on that problem question, okay? Because that's where the bulk of the marks are, but that's where the work really is as well. Okay, you should be using the authorities that I've given you, so the statute and the two cases, to guide your interpretation of the statute and guide your advice to the client. The cases are not the answer, though. It's not a formula of this case plus this case tells us what's going to happen for the client. They will give you some guidance and a part of an answer, but you still need to work on the interpretation of the statute yourself. Okay, so there's still some work in it for you. It's not a formula, sorry. When you do your reflection, you can just put that under a separate heading at the end of the document. You don't need to incorporate it into the rest of the problem solving answer. You can do, one final thing is that you can do additional research if you want, but you must use the authorities that we've given you to guide your answer. And generally, I would say only do additional research to help you get on top of the, you know, the legal issue. It's not necessarily going to bring any amazing results for you. So there isn't an equivalent case. I haven't based this, the problem scenario, on an actual case. So you're not going to be able to find somewhere in the depths of Westlaw the actual case that this is based on, because it doesn't exist. Okay, I didn't want everybody searching for the needle in the haystack. Okay, so it's really about how you approach the question, how you whether it's logical, whether you use IRAC, and whether you think about how to interpret the law and how to apply it. Sorry, who was going to ask a question then?
I have a question about referencing. So if there is something that is explained from a case in the cases provided, do we do like EBID and then the paragraph, or we do write when the original case wrote about this?
Okay, so the first, like if you were citing one of the cases in your assessment, the first time you cite the case, you'd need to give the full citation for it. So you would, you know, whatever the party's name is, plus the year in brackets, plus the law report series and the page number. And then if you're quoting directly from the case, you'd need the pinpoint reference as well. Okay, and that was actually one of the things that was wrong in that extract one, even, was that they didn't have a pinpoint reference for that particular point. So you'd want either the paragraph number or the page number. Then subsequently referring to that same case, you can use IBID if that reference is exactly the same as the one immediately above it. So let's say you've got footnote 1 is the case name, footnote 2, you can use IBID. But if there are other sources in between, you can't use IBID because IBID only refers to immediately above. Excuse me, I'm going to cough. In that case, yeah, you'd have to write N and then the footnote number in accordance with the AGLC. Okay. Or repeat the case citation. Sorry, I'm going to cough. Okay, so
Nicola, I've got a question.
Yeah,
sorry.
Sure.
So, is it normal for us to be making many references to other materials such as journal articles or textbooks, or should we only really be relying on the materials that were provided to us with the assessment?
Okay, so that's that answer depends on the relevant task itself. So let me explain. So let's just say that you were in tort law and you were asked to advise a client on negligence, and it turns out that that particular area has not been before a superior court. Okay, so we don't really know what the law is. We've got lower courts kind of arguing about how to, you know, what the rule is and how it applies. In that instance, you might look to journal articles to kind of reason where the law might go in future if it goes on appeal to a superior court. But that's really the only time that you would really cite journal articles in court. Okay, so you know they're cited in the High Court, for example, when people are trying to advocate for change or help or advocate for a particular interpretation and saying that the law should develop this way. It should develop this way because the law is unclear and it's going to, from a policy perspective, it works better if it develops this way. Okay, so we use academic commentary then. Do we use it when it comes to the magistrate's court or the district court? Do we use it when the law is straightforward and it's really about the application, or do we use it when it's when we're interpreting basic statutory provisions? And the answer is no. We would only be using primary sources. Now, in this instance, I spent a lot of time looking at Westlaw and Lexis and found the primary sources that I thought were most relevant to the interpretation that I'd set you. So you've got really what you need, not everything that you need, but you've got a comprehensive set of materials, or as comprehensive as they can be on this particular legal issue. The rest is up to you in terms of you know, how you advocate for or how you interpret the provision. So the answer to your question is you can get a HD without looking at any other materials other than what I've given you. Okay.
Perfect. Thank you.
All right. But as I say, I don't want you thinking that that's always the case. Like, as I say, if you're in tort law and you're asked to look at an area of the law that's novel and is new or hasn't been formulated properly, then you might be looking at secondary sources just to help shape that argument. But generally, as a general rule, if it's a problem question and you're looking at the application of the law in a lower court, then you're really looking only at primary sources unless the law is unclear. Okay? All right. Any other questions?
Sorry, I've got another one.
Okay.
Again. So I do recall in one of your prior lectures you mentioned that we may find ourselves having to apply the IRAC pattern more than once. So we might even find ourselves applying it even 3 or 4 times for the purpose of this problem-solving exercise. Is that correct?
Yes. So there might be more than one legal issue. And by that, I mean there might be more than one interpretation issue. So it may be that there are several defenses that we could make, you know, several attacks on the prosecution case in terms of whether the client fits within the provision. Okay. So you've got the offense that he's been charged with, and every aspect of that offense has to be made out, otherwise he's not guilty. So that means that you need to look at what can be challenged within that offense, and each one of those things that you think is challengeable is a legal issue and a matter of interpretation. Okay, I can't really say much more than that because this is about what you can do in your assessment. But yes, so you might end up having a couple of different legal issues and working through them individually and then reaching an overall conclusion.
Sure thing. I don't know how I scraped through constitutional law by only applying one round of the pattern of IRAC. So this will be my first time applying it multiple times, and I'm afraid of getting it wrong.
Well, just think logically, what's the best order to tackle these issues? So it's a good idea to, just do a skeleton plan and then, say, is this the most logical way to present those issues? And then think about whether headings help you and the reader understand that you're moving from one legal issue to another.
Too easy. I'll give it a shot. Thank you.
All right. Anyone else?
Is there anyone that you can recommend that we can speak to, just regarding how we write this? Like, do we write it like we write in psychology, or, do we write differently?
Okay, so well, really, you need to have been following what we've been talking about for the last couple of weeks. So you do need to be following the IRAC method. You do need, in the lecture for week 7, we talk about the fact that you need a brief introduction, then the body of your work, which obviously may include IRAC more than once if you've got more than one legal issue, and then an overall conclusion. In terms of how you convey that information, in that extract 1 that I just showed you, you need to be citing sources in support. So you need to incorporate the source into what you write. So you would write, Kirby J said in the following case, or, according to this case, blah, blah, blah. So you incorporate the source into the sentence. And you need to reference in accordance with the AGLC, which we cover in week 5. Other than that, in the task instructions, there is reference to a section in effective legal writing that looks specifically at problem questions. There are some extracts in there that you can use to illustrate the kind of way that lawyers or law students are expected to write as well. And it kind of sets out how to approach a problem question and how to communicate or how to draft your answer to the problem question. So have a look at that as well. It's an ebook in the library. You don't need to buy it. Other than that,
sorry, I missed that. What was that again?
So in the task instructions, there's reference to effective legal writing. The chapter 5, so it lists specifically sections in chapter 5 that look at problem questions. So how to prepare and draft an answer to a problem question. So that's an ebook in the library. So you just need to find it and find the relevant sections. Don't read the whole of chapter 5. It's massive, just the sections that we've pointed you to. Other than that, if you just want help with general expression on how to express yourself, then the ALC can help you with that. They do proofread essays, but they won't be able to help you on the law. They won't know whether the law is right or wrong. None of them are lawyers in there. And in any event, that's not their job. Their job is just to help you with your communication. Okay, so that's about the sum of it. But yes, it will be a bit different to psychology, I'm afraid. It's not really that report style of writing. The referencing is quite different. If you've done humanities previously, again, we're a bit more methodical. We use a lot more headings and subheadings. So my honest advice is to give it a shot, wait for your feedback, and then you'll know what it's supposed to look like. Okay, but in the meantime, sort of equip yourself with looking at effective legal writing, which will go some way to helping you understand what's expected of you in a problem question answer.
I found that legal writing is almost the opposite to everything else that university tells you to do.
Yeah, it is a little bit. It's quite, and that's one of the reasons that we wrote the book, was because we found that two things. Firstly, that students, unless they'd done legal studies at high school, they generally had very little understanding of what law essays should look like, what referencing should look like, how to rely on sources, IRAC, all of those kind of things. But also, we found that in previous, generations, that the teaching of these things wasn't very explicit. We kind of just expected it to happen by osmosis. And so we wanted to make it more explicit for students. And so that's why it's sometimes a bit step 1, step 2, step 3, but it's to really make it clear to everybody what's required. That means that you can dip in and dip out as it suits you. But yeah, it's sometimes just a good sort of hand holder when you're not quite sure what's expected of you. Right. Okay. Sorry. Yeah, sure.
Previously, you've said that when you're dealing with clients, you've got to give them the outcomes of both sides. When we're dealing with each IRAC based on which of the issues, are we telling him that this is the issue, it could either go this way or that way, or are we going with what outcome we believe that we're sort of applying for?
Okay, well, when you identify the legal issue, you need to be saying what the 2 alternative interpretations are. So I'm going to pick something that isn't relevant to the question. Let's say that the phrasing question was domestic pet, and it was unclear whether or not it included a guinea pig, okay, or whether domestic pet was just cats and dogs, right? So in identifying the issue, you are saying the 2 alternatives. You're saying it's possible that a guinea pig is not within the phrase domestic pet, and therefore this section of the statute does not apply to the client. Or it's possible that a domestic pet includes a guinea pig, in which case the client must do X, Y, Z. Yeah. So you've identified the 2 outcomes. You then go through your IREC process, and then in conclusion, you say it's therefore most likely that a guinea pig is or is not within the section. Does that make sense?
Yeah, perfect. Thank you.
Yeah. And we're always talking in likelihoods. We're never conclusive, because we can't promise a result to our client. I mean, it really just depends on the court's decision-making process, and can depend upon what happens on the day of trial as well, or the day of the hearing. So we can never guarantee anything, but we can talk in terms of likelihood. Sometimes it's really unclear how the law will be interpreted, but generally you'll have a gut instinct. So you need to, or a logical, reasoned decision. So you need to articulate that to the client. Try to avoid sitting on the fence wherever possible. As we are providing advice to the client, do we address the client in the exercise? Dear Jonathan, I write no. The answer is no. Good question, Robbie. I did actually put something about that in the Q&A section. So this is to go on the file in the law office, so that everyone can see what our advice at this point in time is. Okay, it's not written to the client unless you're told in the instructions to write to the client or prepare a document for the client. You assume that we're talking about the client when we're writing about them. So instead it would be, it appears that Jonathan is or is not guilty of the offence because. Does that make sense?
It does, yeah, thanks. I was just stuck on that first bit where it said provide advice to the clients. I wasn't sure whether,
yeah, fair enough. That's fair enough. But unless it's very explicit, it would normally be, provide advice for the file, so that anyone that works on the file understands what position's been adopted at that point in time with that evidence. You can also use that file note to actually write to the client at a later date and say, here's our advice on these points. Okay, but it's always best to check. And, if you have any doubt about that in any of your other units, always check as well as to what they're looking for, and look very carefully at the wording as well. Obviously, if they say write to the client, then you're doing a letter. Okay.
That would be a scenario. Would it be in a law firm, just for side topic? That'd be something you would do, write advice like that and put in the file so someone else can access it?
Yeah, absolutely. Yeah. So if you're a paralegal in a criminal law firm, you might do a file note which includes your assessment of the law, what areas that you need to look into in more detail, or what areas someone needs to look into in more detail, whether you need advice from counsel on a particular point, whether you need to go to an expert. You know, you make notes on the file, and that would be included in that. Okay. I mean, lawyers have got to get their billing hours up somehow, haven't they? Okay, so that's it for this week. I will be around tomorrow at 12 for the Q&A sessions. Make sure you check out the frequently asked question bit that I've put in there. I think there's 5 or so. As questions come in, I'll keep adding them. So it's a good idea to check on that every couple of days just to make sure you're not missing out on anything else that anyone has raised. Other than that, have a wonderful week and weekend, and I will see you this time next week. Okay, thanks everyone.
Thanks, Nicole.
Thank
Bye.
you. Bye.
Thank you.
Thanks. See
See
you.
ya. Bye.